His Excellency the President of the Republic of Ghana, Nana Addo Dankwa Akufo-Addo, the Honorable Attorney General and Minister for Justice, Justices of the Superior Court of Judicature, President of the ECOWAS Court, Honorable Minister for the Upper East Region, and other regional ministers herein present, Ministers of State, the National President and other executive members of the Ghana Bar Association, Chana Pio, President of the Upper East Regional House of Chiefs, the Tongo Urana, Member of Council of State, the traditional leaders herein present, President and executives of the various regional bar associations, our host, Reverend Eastwood Anaba, the clergy, past President of the Ghana Bar Association, distinguished members of the Ghana Bar, distinguished ladies and gentlemen, friends of the media. It gives me great pleasure to join you here at the annual General Conference of the Ghana Bar Association. I thank the National President and executives of the Ghana Bar Association for the kind invitation to this year's conference. It is my hope that this conference will help in advancing the cause of justice and equip members with the will, desire, and essential tools to discharge their duties as officers of the court in a country founded on the promise of freedom and justice for its citizenry. While acknowledging the theme for this conference, which is, quote, ensuring an increase in revenue mobilization through taxation for the purpose of accelerated national development, the role of the lawyers, end of quote, I have been asked to address you on any topic of my choice. The hub of my address is on efficient administration of justice, the lawyer's role. The fundamental role of the judiciary is to provide fair, cost-effective, and impartial justice. The official business of the court is to administer justice for the purpose and on behalf of the people as stated in Articles 125 Clause 1 and 126 of the 1992 Constitution. But at the very center of the official business is the lawyer, who to a large extent determines the success or otherwise of the court's official business, not only in terms of his client, but the general administration of justice. The unique position of the lawyer in the administration of justice was adequately captured in 1994 by John J. Parker, a senior judge of the United States Circuit Court of Appeals for the Fourth Circuit, when he stated in an address delivered before the annual meeting of the Indiana Bar Association that, quote, no more important duty confronts the American lawyer than that of improving the administration of justice. The statement of his lordship, Justice Parker, holds even more truth when applied to Ghanaian jurisprudence. With a judiciary that is still developing, course lists which get more overcrowded every day, and the population appreciating its rise more keenly than ever, the role and duty of a lawyer in ensuring an effective and efficient administration of justice has become even more paramount. A trial judge hearing a case without lawyers finds justice delivery very difficult. The lawyer is undoubtedly an important stakeholder in the pursuit of an efficient administration of justice in Ghana. This morning, I am delighted in sharing with you my passionate thoughts on this subject and how lawyers may contribute to the objective of achieving an efficient delivery of justice to the level desired by all stakeholders in the justice system. One way lawyers may contribute to the efficient administration of justice is by ensuring better communication with clients. Lawyers must take the first step of explaining every step of the process, the possibility of success or failure, the expected legal challenges and obstacles, and the like to their clients to ensure that the client has a realistic view of the nature of his case. The lawyer must appreciate that simplifying the court processes makes the court more comprehensible and accessible to the client. The complexity of the justice system, which can sometimes slow down cases and make the system difficult to operate and navigate, should be appreciated by the client and should not be used by some lawyers as an excuse to delay proceedings. The lawyer must at each step of the process explain the proceedings to the client in a candid and realistic way. Placing greater reliance on alternative dispute resolution is another sure way a lawyer may contribute to the efficient administration of justice. Improving communication with your clients include educating them on ADR mechanisms available for settling disputes. As we are aware, the ADR processes are relatively less expensive but more rewarding in terms of time spent in arriving at a decision. Aside ADR, lawyers have a duty to pursue good faith efforts at settling matters without recourse to court, if the matters may require such a settlement. Even when the substantive matters are not amenable to settlement, lawyers should explore, if possible, which of the issues could be resolved out of court and which ones rightly deserve to be put before the judge. Lawyers must also respect the courts and its orders to ensure an efficient administration of justice. As a matter of public policy, and indeed as a function of the integrity of a lawyer, it is important that the authority of the court and the sanctity of its processes are maintained at all times. It is not acceptable for a litigant or a lawyer to decide which orders to respect and which orders to disregard. Courts are lawful and therefore deserving, orders are lawful and therefore deserving of obedience. It is tried knowledge that an order or process of a court of competent jurisdiction cannot be impeached by disobedience. Lawyers must make their very best to their clients at every stage of the trial. Failure by a lawyer and or his client to obey the orders of the court not only undermines but has the potential to destroy the administration of justice. An adherence to these tenets should result in the expeditious disposal of cases, though decongesting the court to hear more cases and administer justice to a greater number of people in a relatively shorter period of time. Upholding the duty of candor, particularly in the service of court processes, is another area where lawyers can contribute to an efficient administration of justice. Adjournments may be sought only on legitimate grounds and in the interest of justice to advance efficient administration of justice. It is possible for lawyers to agree on adjournment dates even before they go to court and inform the court accordingly. It is disheartening, however, how often judges criticize the procedure adopted by some lawyers, as well as avoidable delays caused principally by some lawyers deliberately. An over-reliance by lawyers on Order 81 of the High Court Civil Procedure Rules 2004 CR 47, that non-compliance with the rules should not render proceedings void, has resulted in a tendency for lawyers to go contrary to the rules, only to come to court and pray for their irregularities to be cured by Order 81. The impact of delays in the administration of justice was reiterated in the case of Ajiman, substituted by Banahene and others, versus Anin, reported in 2013-2014, One Supreme Court of Ghana Law Report, page 241. My respectable sister, Wood CJ, put it clearly at page 247 that the oft-quoted legal maxim, justice delayed is justice denied, has come to the fore. The right to a fair trial in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, but as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, the lawyers who practice before the courts, and everybody who has something to do with the justice system. A number of issues I have discussed with you regarding the lawyer's role in ensuring the efficient administration of justice have now been given the necessary legal backing. Rule 29 of the Legal Professional Conduct and Etiquette Rules 2020, LI 2423, for instance, imposes a duty on a lawyer to inform his clients of the reasonably available alternatives to trial, and some of these provisions should be strictly enforced by the Disciplinary Committee of the General Legal Council if the need arises. The judiciary will continue to collaborate with the bar to continue to put measures in place to decongest the courts. The establishment of more courts in the country will greatly increase the access to justice, as is being done currently. This is even more necessary when one considers the effect of long-distance travel, time and money spent by litigants, the consequence of which is that longer adjournments should be a thing of the past. Simultaneously, the use of administrative tribunals run by seasoned professionals in other jurisdictions, would be explored and replicated in Ghana in due course as a way of decongesting the courts. It is regrettable that few administrative tribunals exist in Ghana to complement the efforts of the judiciary. Over 50 years after the Akosombo Dam was built, we still have compensation claims in courts at Ho, Hohoi, Koforidua, which have and could have been easily resolved by administrative tribunals. Another area in which administrative tribunals can help us is the area of insurance claims. Amputees and injured persons may have to resort to the judicial process for years. This could easily be resolved through administrative tribunals, where lawyers will be candid to admit liabilities. Let me end by re-echoing one of Abraham Lincoln's quotes as edited by Roy P. Basler on the role of lawyers as follows, quote, "Discourage litigation if possible. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expense, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough." End of quote. On this note, I officially declare this annual conference duly open, and I wish the Bar Association a successful annual conference. Thank you.